Welcome to Part 10 of our video series on detailed reading of the Digital Personal Data Protection Act 2023. Please check the Part 1 to get an overview of the various chapters in the DPDP Act. Part 2 to Part 9 has detailed review of Chapters 1 to 8. In this video, we'll be reviewing Chapter 9 of the Act, covering its key sections and compliance structure. As discussed in the Part 1 video, the DPDP Act 2023 is organized into 9 comprehensive chapters, and scope of this video is Chapter 9, referred by the Act as Miscellaneous. Chapter 9 includes 10 sections, from Section 35 to 44. Key provisions cover protection in good faith, consistency with other laws, power to make rules, and laying of rules before Parliament. The penalty cap limit is set at double the maximum penalty prescribed in the schedule. Section 35 is regarding protection of action taken in good faith. As per the section, no legal proceedings can be brought against the central government, the board, its chairperson, or any member or employee for actions done in good faith under the Act or its rules. Section 36 is about power to call for information. As per this section, the central government may require the board, any data fiduciary, or intermediary to furnish information for the purposes of this act. Section 37 is about power of central government to issue directions. Subsection 1 grants the central government power to issue directions. This can occur if the board intimates the imposition of a monetary penalty on a data fiduciary multiple times, or advises blocking access in the interest of the general public. Continuing with Section 37, as per subsection 2, every intermediary receiving a direction to block access must comply. As per subsection 3, for this section, the definitions of computer resource, information, and intermediary align with the Information Technology Act 2000. Section 38 addresses consistency with other laws. Per subsection 1, the Act's provisions are in addition to, and not in derogation of, any other law in force. According to subsection 2, in case of any conflict, the provisions of the DPDP Act shall prevail. Section 39 establishes a bar of jurisdiction. No civil court shall have jurisdiction over matters for which the board is empowered under the Act, and no injunction shall be granted regarding actions taken under the Act's powers. Section 40 is regarding power to make rules. Subsection 1 grants the central government the power to make rules via notification. Per subsection 2, these rules must be consistent with the Act and may address the manner of notification, accountability, and registration of consent managers, among other matters. Continuing with subsection 2 of Section 40, the power covers rules on subsidies, intimation of personal data breaches, the time period for specified purposes, and the manner of obtaining verifiable consent. Additional rulemaking powers under Section 40, subsection 2, include matters comprising the data protection impact assessment and other measures for significant data fiduciaries. Rules can also govern how a data principal requests information or erasure of personal data, and the response time for grievances. Section 40, subsection 2, also covers rules regarding the manner of nomination, standards for processing personal data for exemption, appointment of board members, and the terms and conditions of service for the board's officers and employees. Furthermore, Section 40, subsection 2, allows for rules on techno-legal measures by the board, the form and fee for filing an appeal, the procedure for dealing with appeals, and any other matters necessary for the Act's implementation. Section 41 is regarding laying of rules and certain notifications. It mandates the laying of rules and notifications before each House of Parliament for at least 30 days. They will only take effect in a modified form or be of no effect if both houses agree to such changes or annulment. Section 42 is about power to amend schedule. Subsection 1 grants the central government the power to amend the schedule by notification. Per subsection 2, any such amendment cannot increase a specified penalty to more than twice the amount originally enacted in the Act. Section 43 is about power to remove difficulties. Per subsection 1, if any difficulty arises in implementing the Act, the central government may issue an order in the Official Gazette to make necessary provisions, as long as they are consistent with the Act. Per subsection 2, such provision can be made only up to 3 years. The order needs to be laid before each House of Parliament, as per subsection 3. Section 44 concerns amendments to certain acts. Per subsection 1, the Telecom Regulatory Authority of India Act 1997 is amended to include the Appellate Tribunal under the DPDP Act 2023. Continuing with Section 44, per subsection 2, the Information Technology Act 2000 is also amended. Section 43A and Section 87, subsection 2, clause OB are omitted. The DPDP Act 2023 is inserted in the proviso of Section 81. As per subsection 3, the Section 8 of the Right to Information Act 2005 needs to be updated by updation Section 1, clause J, to be information which relates to personal information. We recommend the Kalpi Quiz app, available on the Google Play Store, to test your knowledge of cybersecurity, the DPDP Act, and other important topics. The app offers various levels of difficulty and interactive assessments to improve your awareness. Thank you for watching this video relating to the raw reading of the DPDP Act. Hope you now know more about the chapters of DPDP Act. This was the 15th video in this series, released by dpdpamentor.in. Please visit our YouTube channel, DPDPA Mentor, as well as our website, dpdpamentor.in, regularly to check out other informative resources. Wishing you a successful DPDP Act implementation.